My Lord, I'll respond very briefly, if I may, in relation to the points that the Court had asked us to consider. First of all, we will, of course, file an agreed note in relation to the procedural points raised by my Lord Stevens within whatever timescale the Court requires. Secondly, in relation to Abbasi, it is common ground now amongst all the respondents to the appeal, not including the Secretary of State, common ground amongst the respondents and the appellant that the inherent jurisdiction in this context only applies to children. The only caveat to that, my Lord, is that if there were to be the inherent jurisdiction exercised and an appeal, and following a successful appeal, the case had to be remitted for a reconsideration of the merits of the application originally made when the child was a minor, the case would need to be redetermined, notwithstanding the child having achieved his or her majority, because the merits of the case couldn't be dependent on the timing and listing of an appeal. It is common ground amongst the appellant and the respondents, therefore, that the appeal has become academic on the facts of this case, given X and Y's ages. Neither of them could be assisted by the use of the inherent jurisdiction here. As a separate point, having reflected on my Lord Sale's observations in particular about the use to which Article 8 might be put when interpreting the statute, and whether...
I'm sorry, just before you move on to that, you say it's common ground that your appeal is academic, but I thought you just before that said if the appeal is allowed, it would have to be remitted, and then there would be consideration. I mean, one might question this, but I think you were saying consideration as if your client, the children were still children, in which case it wouldn't be academic, would it?
How old were they before Mrs. Justice Leven?
So that the order made by Mrs. Justice Leven was the 25th of April 2024, and both of the children were children, in fact.
They were.
On that date. So yes, your Lordship is right.
So it's not an academic appeal on your submission, is that right?
Forgive me, yes.
Okay.
But I just don't understand the qualification you're putting in. If you remit it and the court hasn't on remittal got any jurisdiction, what can it do about it? It may be a reason to have expedition in the hearing of an appeal so it can get back to the court with jurisdiction. But if the court no longer has jurisdiction, what's the court to do?
That would require an interpretation that the inherent jurisdiction was available, notwithstanding the children had achieved their majority by the time the case came to be remitted, but based on their being minors at the time the application was made.
I just don't understand that. The inherent jurisdiction terminates when the people become adults, and I thought you had agreed to that. And how does it get revived in situations where a case is remitted?
Well, in a case such as this, where the question of revocation goes to the status of the child in the long term, it would not be appropriate for the long-term outcome to be dependent.
All you have to do is ask the Court of Appeal to hear the case with the expedition.
I certainly agree with that.
Then you solve this problem. No expedition was asked for, and the matter is now entirely academic. At the moment, I can't see the legal basis for saying that a High Court judge has an inherent jurisdiction if the matter is remitted to that judge after the individual, the children, achieve adulthood. Can't understand it.
Well, our argument is, in that respect, is founded on the children's minority at the time the original hearing was made, and by implication, an extension of the court's powers then to bridge the period into adulthood, to redress any problems with the original decision that had been identified on appeal.
But the fact that the court had jurisdiction at the time of the original decision doesn't mean it has jurisdiction to deal with a remit following an appeal.
So be it, my lord. As far as my Lord Sale's point in relation to Article 8 and whether or not we pursued a case under Section 3, again, I speak for the appellant's position and those of the respondents other than the Secretary of State. We accept that this case is now purely about statutory interpretation. We do not, as before, make any submissions about incompatibility. We are not asking for a Section 3 read-down. And accordingly, we accept that Article 8 is not relevant to the court's interpretation of the statute. Finally, there was an issue right at the outset of my oral submissions in relation to anonymity and any reporting restriction. It seems that the party's likely use throughout today's hearing of generic initials means that on the ground a reporting restriction order is not going to be necessary. I understand, having not appeared below or at first instance, that Mrs. Justice Leven asked for and received a schedule of anonymisations in the usual way so as to achieve anonymity within that hearing. Before the Court of Appeal...
She didn't make any order, is that right?
She didn't make a reporting restriction order because no press attended and the issue didn't arise.
Well, it didn't. Reporting restriction orders affect those people actually in court, namely barristers and solicitors. You don't need to have press there for there to be a requirement for a reporting restriction order.
But it would be very, very unusual, my lord, if not unheard of, for a judge to make of their own motion at first instance a reporting restriction order where no press or third parties were in attendance or seeking to be.
Well, I certainly did.
I'm sorry, my lord?
I certainly did.
And then, my lord, before the Court of Appeal, I understand that the live link failed before the judges came into court, and so there was no discussion before the Court of Appeal about a reporting restriction order on the facts of this case, although there usually is when there is a live link. I repeat, in the circumstances of where we are before this court, it doesn't appear that an order is necessary because of the use of initials. My lord, thank you.
We're going to be writing a judgment. So...
well, I mean, we were anxious to know if there was an order and the terms of any order. It sounds as if there is no order currently in place. And nevertheless, there might be a basis for anonymising parties to essentially avoid embarrassment through private matters entering the public domain.
And the point is made by at least one of my learned friends that even if the two former children who are subjects to this appeal are now adults, yes, there are other related grandchildren and children who don't have that status.
Yes, yeah. Yes, well, it's subject to anything anybody else may say. I don't myself see a problem about anonymising the appellant and the respondent.
Yes.
Isn't there a recent Court of Appeal decision that reviewed all this? A judgment given by the Master of the Roll. I think following Abbasi and Wolverhampton and Gypsy, and I think after reviewing it all, they decided that well, certainly anonymisation would be appropriate in cases where matters that ought to remain private would otherwise be made public.
Yes.
I mean, unless anything has actually been said in court or is otherwise available to people to publish, there doesn't seem to be a need for what one might properly call reporting restriction order, because what is there to report? I mean, we've simply been discussing points of law. But if, it's different, but the anonymisation is a different matter.
I certainly agree there's a difference in approach required for the hearing itself and then the judgment thereafter. Thank you, my Lord.
Yes. Well, it sounds as though it might be sensible for us to anonymise our judgment and to make an order requiring that anonymity to be respected, subject to any submissions that anybody else may.
I understand that collectively we would all seek an order in those terms. Thank you, my Lord.
Thank you, Mr. Goodwin. Yes, Mr. Norton.
My Lord, my Lady, I am enormously grateful for the time given in rising early so that I can reflect on my submissions, and also, as my Lord and my Lady have heard, there have been some useful discussions outside of court as to a collective position. And so, subject to anything that the court may raise with me, I will be well within my 15 minutes of speaking time and likely much shorter. The written case on behalf of BM is, of course, within the bundle from page 125, and I'm not going to repeat the contents of that. As I have within that document adopted the core submissions on behalf of the appellant, I again adopt, if I may, the submissions made by Mr. Goodwin, King's Counsel, to this court this morning, subject to one brief matter I will address in a moment in respect of the inherent jurisdiction. And therefore I don't seek to repeat his submissions to this court. But I think in my consideration over the shorter Germans, I've got 4 brief matters I would wish to address, and of course anything that the court has for me. The first of those does address the issue of anonymity, and I certainly would invite this court in its judgment to use the anonymisation that we have used, and an order that suggests that that anonymisation should not be lifted would meet the expectations of BM in this case, as my lords and my lady have heard. Although the subject children, as I call them that, are no longer children, there are other family members who require protection and their private lives to be maintained as private. The second matter that I was proposing to address briefly, orally, but as my learned friend Mr. Goodwin, King's Counsel, has indicated, it may be that this court will accept some brief written submissions on this matter, relates to questions which arose at the start of this hearing in terms of the jurisdiction of the family court as a statutory body. My lords and my lady will know, of course, that the family court was devised by the Matrimonial and Family Proceedings Act 1984, and in terms of its jurisdiction, that can be found. I'm afraid that this Act is not within the extensive funding authorities, but can be provided. The jurisdiction of the family court arises from section 31, capital E, of that particular statute. And that sets out that the family court has, amongst its powers, the powers of the county court and the high court. The powers of the family
and is that a provision that came in 2014?
My lord, I believe so, but I will confirm.
It's just, I mean, Lord Stevens and I wrote a judgment relatively recently in a case where we had to look at the inception of the family court, yes, as a statutory court, and I think we said, presumably on the basis of what we'd been told at that time, it's 2014. I just wanted to confirm that that is accurate.
I am looking, my lord, at the statute on the relevant website. Just confirm. Section 31E, I hope I'm not misspeaking, and others hopefully will correct me if I am. Section 31E was inserted by the Primary Courts Act 2013, came into effect on the 22nd of April 2014. So I think my lord.
Right. Okay, so that does seem to fit,
yes,
with what we were talking about.
Thank you,
yes,
my lord. Yes.
And so although the statute sets out there under section 31 capital E that in any proceedings in the family court, the court may make any order which could be made by the High Court if the proceedings were in the High Court, or could be made by the County Court if proceedings were in the County Court. That issue has also been considered by case law, and the authority for that, my Lord, is a Court of Appeal authority of REK, Children Powers of the Family Court, 2024 EWCA Civ 2, and the headline paragraph for that, given in the lead judgment of the President of the Family Division, says this appeal is an opportunity to reaffirm the wide and flexible powers of the Family Court. Where proceedings have been properly issued, the judge or magistrate to whom the case has been allocated may make incidental and supplemental orders of a kind that could be made under the inherent powers of the High Court, where the purpose of such orders is to give effect to their substantive decision. And so what I submit, my lords, my lady, is this, that of course that authority is clear that if there is a case proceeding in the family court but requires an ancillary order not provided for by statute, a judge in that court could make that order. What is clear from the allocation provisions is that a freestanding inherent jurisdiction application could not be heard in the family court and is to be heard in the High Court. The family court judge can only make orders outside of the statutory scheme if they are ancillary to the main order that they have made.
I'm sorry, you did say that section 31E said, I think, that the family court has all the powers of the High Court. So why, if an attempt is made to invoke the inherent jurisdiction, do you have to go to the High Court?
My Lord, that arises from the allocation provisions issued, which states that an application, a freestanding application under inherent jurisdiction, is to be heard by a judge of the High Court.
Right, so there's some other instrument that makes that clear.
Yes.
And what's that?
And the other instrument is...
Which provision was that?
I'm so sorry.
You just quoted from which provision is that?
I've quoted from the case of REK in paragraph 3, and my lords don't have that authority. We will have to provide it.
No, but you referred to another instrument. And
yes, the other instrument. I'm just looking. I have a number of screens open. I do apologise.
So is that why deprivation of liberty is dealt with by High Court judges and not in the family court? Or yeah, oh, maybe.
My lords, I can hear a whisper behind me. But
yes. We asked.
Yes, I'm allowed to do that. Yes. I should say, Mr. Norton, I gather we're going to get an agreed note about the jurisdiction of a family court, and helpfully also the appeal routes, and perhaps the note could also give us a note of this material.
Yes, there are allocation provisions made in 2021 by the President, but we will provide those to the court so that you can see within that the table of those cases which must be started in the High Court, those that can be started in the family court, and then within the family court, the allocation amongst the various different judges of that court as to the types of cases they may hear.
I see. So actually, an application to invoke the inherent jurisdiction would be made in the family court, but it's just that the allocation would be of a High Court judge to hear that application. Is that right?
My Lord, I cannot find it in front of me. But
all right. Okay.
I think I would not be. I think I would be wrong to agree with my Lord on that. I think it is that an application of the inherent jurisdiction has to be in the High Court.
Okay.
rather than in the family court. But
Okay. It was just the way you
provide-
described the allocation power.
Yes.
It sounded like it was a power to allocate business within the family court.
Yes, within the family court, so cases which are properly brought within the family court, there are then allocation provisions which indicate which level of tribunal within the family court certain applications should come before.
Yes.
And so, for example, care and placement orders can be dealt with by magistrates and
Yes.
district judges, but levels of complexity require those cases to be heard at a higher level in certain circumstances.
So a placement order made by a district judge then is appealed to a circuit judge, is it? Or is it, well, I won't inquire any further. It's okay.
My Lord, private law matters have the ability to go from a county court judge to a high court judge, but public law matters are, in terms of appeal, are preserved for the Court of Appeal.
Anyway, you're going to help us with
Yes, absolutely.
a note that deals with all.
And could we ask for that note within, say, 7 days? Would that be realistic?
The next issue is in relation to the inherent jurisdiction, and I don't seek to undermine the submissions made a few moments ago by Mr. Goodwin, King's Counsel, in terms of the inherent jurisdiction. It is agreed by the respondents that once an individual reaches the age of 18, that falls away. I don't pursue an argument that if the application was made prior to the individual reaching 18, on remission, the jurisdiction could be used. I'm not aligning myself with that aspect.
Right. And can I ask just on another aspect of the inherent jurisdiction, do you accept that it was never part of the inherent jurisdiction to allocate parenthood one way or the other?
One way, perhaps not the other. Perhaps and that was my fourth point,
Right.
my Lord, that I was coming to. And that will depend, I suspect, on this court's interpretation of language. I accept entirely, my Lord, that statute alone, not common law, had created adoption. And therefore, the creation of a parental relationship in that way is a creature of statute. It will come down, my Lord, to this court's interpretation as to whether there is a material difference in relation to creation of parenthood or resumption. So is a revocation, and so that the child then becomes a child of their birth parent again, is that creating a parental relationship? Is there a material difference between that and restoring a parental relationship?
But I'd have thought, since before the statute, you couldn't move parenthood away from the natural parent.
Yes.
Doesn't it follow it was never part of the inherent jurisdiction to move it back again because it was a situation that could never ever arise?
Yes, but whether, now that statute has created an ability to move parenthood in one direction, I understood my Lord's interventions earlier this morning to be, therefore it means that it cannot then flow back, as it were, because it has been extinguished at the time of the adoption order. I would invite a more generous interpretation of language to say that although inherent jurisdiction hasn't been used to create parenthood, it can be used to restore it.
Even though it never was and historically could not have been. Well, can you assist us with that? Where on earth did this inherent jurisdiction come from? It seems never to have existed on what you're telling us.
It didn't exist because it wasn't required, because at the time the statute had not been, there had been no statute that created the adoptive relationship. Once that statute is in place and creates the ability to move parenthood from one to another, the inherent jurisdiction, which is used, it's clear from the authorities as a required safety net, is there to meet the needs of a particular child if there is a revocation.
Right, but it never was there. Suppose that a child had some pressing need to move its parenthood, their parenthood, away from their natural parents. Well, the inherent jurisdiction never existed to do that. So I'm struggling to understand the submission that just because there's a need in this sense, an inherent jurisdiction springs up.
Yeah.
But it's a need created by the statute, because the statute has created the ability of a legal order to move parenthood from one individual to another. The statute under the 2002 Act doesn't provide a mechanism for revocation, save under Section 55, and therefore the inherent jurisdiction comes into play as a safety net for those cases that we say had been the position of X and Y.
I think that's what I'm pressing you on.
And the problem is it's a prerogative. We're into constitutional law here. It's a prerogative power, and it'd be very odd if a prerogative power that didn't previously exist came into being as a result of the enactment of a statute.
My Lord, I think I'm going to have to say that there has always been the power for the court to intervene under its parens patriae jurisdiction to protect those who fall within the ambit of the inherent jurisdiction. Perhaps my answer would have to be the power was always there, but it was not required to be used because the adoption was not in existence. There's always been the power there. It is become, as it were, relevant and is now needs to be utilised because of the enactment of the various adoptive legislation over the course since the 1920s.
But I thought that you had accepted that however pressing the interest of the child in relation to a natural parent might be to change their parenthood, there wasn't a power. I thought you'd accepted that. So there simply was no power under the inherent jurisdiction for a court ever to order your natural parent is X, but we, the court, are making an order to say that your parent now in law is going to be Y.
In fact, if you like, wardship is rather an illustration of it. I mean, the way the inherent jurisdiction dealt with the problem of orphans wasn't by giving them parents, but by creating the institution of wardship.
My Lord, I think I'd have to resile from what I'd said earlier to this extent. Rather than say it was not, the power was not there, it was there in the shadows, but was never exercised. And I can't conceive of a situation, nor can I provide a case which shows where that inherent power was used by anybody prior to the adoption legislation to seek to move their parenting from one individual to another.
So just as I'm clear about what you are saying, you're now saying there always was an inherent jurisdiction in the court to change someone's parenthood. But even in the case of a natural parent, the court did in fact have this power, even though it was never ever exercised.
My Lord, I think I'd qualify it in this way. There was always the power of the court under its inherent jurisdiction to protect those who required that protection. I'm not sure that it would ever have been used to change parenthood in the way that adoption changes parenthood, but conceivably I would have to say it would, because otherwise I then fall foul.
I think I had summarised your eventual submission correctly. You're saying that there was always an inherent jurisdiction in the court to change someone's parenthood, even in relation to a natural parent. That's what you seem to be saying now.
In circumstances where
there's a pressing need,
yes,
and you say, yes, you can do it.
but it has not been used because there are other ways, as my Lord Reed has indicated, where that could be, where protection could be achieved short of changing parenthood.
Yes, thank you.
And there's absolutely no authority to that effect.
My Lord, no.
Well, perhaps I could put this to you, that I mean, Lord Reed in, I think it's Burma Oil, going back to what my Lord was putting to you about the nature of the prerogative, described the ongoing prerogative to the extent it exists as, I think he says, an ancient relic, or at any rate, something that was wide before but has been cut down over time through statute and so on, leaving a small residue. It just seems a very strange submission for you to be making, that even though there's no evidence historically of this inherent jurisdiction ever existing, that nonetheless somehow it survives as part of this historic residue. Is there anything more you wanted to say about it?
Well, I think only this, that I can't identify a case where it was felt that that was the proper exercise of the inherent jurisdiction, because there would have been other ways of protecting the vulnerable individual. Once statute has created the idea of moving parenthood rather as opposed to wardship or some other protection, there ought to be the way to reverse that in circumstances which are considered by the court to be appropriate.
Yes, thank you.
I'm just looking, my lords and my lady, if I may, just at my notes to see whether there are any other matters on which I had considered I ought to address the court. I don't believe so. I think those were the four matters. Can I assist the court?
No. Yes, I see we do have the Kaiser's Royal Hotel in the bundle, and just looking at page 1151, there's a well-known definition of the prerogative, which is along the lines of what Lord Sales had in mind. Towards about two-thirds of the way down the page, the prerogative is defined by a learned constitutional writer, who I suspect might have been Professor Dicey, as the residue of discretionary or arbitrary authority which at any given time is legally left in the hands of the Crown. So it's really, we're looking at the residue of what was held by, for example, Edward I. Right. Well, thank you very much, Mr. Norton. Yes, Mr. Bow.
My Lord, my Lady, I appear on behalf of Y, together with Mr. Cooper Hall, who sits behind me. Our written case in relation to this appeal appears in the bundle at 85. And we have also contributed, which I, in due course, will invite the court to consider, to the statement of facts, and also the chronology which underpin the circumstances relevant to her and the journey that she made from the point of being removed by the local authority and eventually placed for adoption. The statement of facts are at 73, and the chronology is at 82. I should begin by saying that we align ourselves with the observations made on behalf of the appellant, but there are just a number of very short matters which I would like to address with you, if I may, which are pertinent to Y and her circumstances. I've been allocated 30 minutes, but I suspect that I won't take all of the complement of my time. The first point that I was going to mention was an explanation in respect to how the judgments in the previous proceedings and the courts below came to be anonymised. And they were in relation to guidance issued by the President, two sets of guidance, one from 2014, which I can provide if that will be of eventual assistance, which identifies that in public law proceedings in relation to proceedings in the family court, it's usual practice for children to be anonymised as well as parents in those proceedings. And the subsequent anonymisation guidance, practice guidance, family court 2018, amplifies that guidance and also encourages courts to consider two checklists in relation to the anonymisation and the avoidance of identification of children in judgments based in the public arena. Those two guidance documents underpin the way in which the courts below function in relation to family proceedings, and having appeared in front of Leave and J, the reason that we ended up anonymising in that way was in keeping with that guidance, and in the Court of Appeal, the same applied. The point that's been made by the appellant...
Just on that, could we ask for those to be included in the pack of information that we're going to be given?
The process underpinning them is a greater move towards transparency in the family court, but obviously maintaining the right balance in relation to Article 10 and Article 8 rights of family members. In terms of the approach here, obviously, I think the position has been made that anonymisation would be preferable, and certainly in relation to my client, due to the fact that she has now, subsequent to the Court of Appeal decision, had a child of her own, and that there are other children in the case in relation to X and also BM, we obviously would support the submission that that would be an appropriate way forward. In terms of the next matter that I was going to raise, it's in relation to the parens patriae authority in relation to the utilisation of the inherent jurisdiction. It is accepted, as has been pointed out by the appellant, and in relation to X, forgive me, for Y, that the position for her, given the fact that this appeal was not expedited, means that she falls outside of that. The reason that I'm alighting upon that with reference to the statement of facts is because plainly when this case was first issued, it was issued in respect of public law proceedings which came about during the time that Y and X were placed with AM. The application was made alongside those proceedings, and obviously they've taken time to travel through the court. She was, at the time of the decision by Mrs. Justice Leven, 16 years old, and she was 17 years old at the time of the Court of Appeal decision. And so, obviously, having turned 18, I think, last week, she has just fallen short in relation to the way in which this appeal has been brought for determination.
Again, sorry, just so that I can understand, does that mean that you are not submitting that if the appeal were allowed and the case were remitted, that there would be any scope for exercise of the parens patriae jurisdiction in that case?
If the power exists and the case were remitted, there'd be no power on the application to remit to revisit her circumstances. In terms of the next point I was going to make, which is with reference to her journey towards the position that she is in now, it really is crafted around an observation made by my lord in relation to identity formation. One of the observations made on behalf of the exchanges with the appellant was how and in what circumstances and what age identity formation begins to take hold in terms of the circumstances of a child, and whether any application to revoke becomes more or less powerful as a child travels through their childhood. The point I would make in relation to that, using wise circumstances, if I may, as a template, are that all of the hallmarks in relation to her journey towards her adoption order indicate that the philosophy of the Adoption and Children Act and the those matters which underpin its basis in terms of embedding a child in a family's certainty and finality never took hold in relation to Y. And the reasons I say that are, very quickly, she was 5 years old when she was adopted. She was 7 years old when life story work and specialist therapy was brought into effect in order to assist her in embedding into placement. She was 7 years old when she took the view that she had two mothers and referred to both of them in that sense. And she was 12 years old when, in fact, she moved to live permanently with BM, thereby severing all of her personal, social and other ties in relation to AM. The reason I say that that's relevant is because when one looks at her particular circumstances, the reason why she was provoked to support the appeal was because, from her perspective, she never, in fact, benefited from the scheme, which is under discussion now. She did not benefit from the court's evaluation of the benefit to her welfare throughout her life under the statutory checklist, and she did not benefit from an adequate evaluation of the meaningful relationships which are under consideration by the court under section 14F when determining whether or not the care plan for adoption was proper for her.
Right, but I don't think you're contesting, are you, that the court making the adoption order did think that it was going to benefit her, and that's why it made the order.
Yes, and at the time when the order was made, yes. I suppose the point I'm making inarticulately is that were those facts to be known at the point at which the adoption care plan were sanctioned, it likely would never have been a plan that would be agreeable for the welfare of this child.
Right, but I'm not sure where that takes you. I mean, obviously people don't know the future. Whenever a court exercises a jurisdiction in a particular way, isn't the onus on the court to use the checklist to do the best it can to assess the child's welfare in the circumstances? You don't contest that that happened here? No,
and I'm not...
So how does that help in what we have to determine about the nature of the adoption order? Because clearly there are social policy reasons in many cases, put it no higher, why one would want an order to be treated as final. Why is it shown that that is an illegitimate concern or purpose just because in some cases, as is almost inevitable, things don't transpire as everyone in fact hope they will do at the time the order is made?
The only reason I refer to it is because of the issue of the identity formation, and there are circumstances such as this for Y, where her identity was never transferred in that way to becoming embedded in the family of AM.
I mean, I follow that, but I'm asking for how it helps us in what we have to determine as a matter of statutory interpretation.
Well, I accept that on this point, this would go more to the issue of if there were to be a power, how would that power be addressed, and how would those issues of relationship identity be considered under an inherent jurisdiction which would exist to look at revocation. It would be the second point. I should have made that clear. In terms of statutory interpretation, I think I have to accept that it wouldn't assist the court in terms of identifying whether or not it would be right that there be an inherent jurisdiction in the first place. The other point which I was going to raise, albeit briefly, was merely by way of explanation as to the circumstances in the Court of Appeal as to how it arose that when the prospect of Y being adopted again by her birth mother was something that she ultimately rejected. And in terms of the legal position, I accept that it would mean that she would be adopted by her parent. But from her perspective, the view that she took is that it would be, again, an artificial arrangement and one from which she was hoping to escape in terms of being an adopted child, being known as an adopted child, having the status of an adopted child, is not overcome by the fact that she would end up being adopted again by her mother. And I only wanted to mention that because it was mooted by the President in the court below, and it was something that caused her particular anxiety and upset, it was suggested. In terms of the...
Sorry, just on that, I mean, would you accept that a re-adoption order, if it had been made, would at least have gone some way to meeting her concerns? I appreciate it wouldn't be the optimum solution from her point of view, but if it was very important to her psychologically that her birth mother be acknowledged to be her mother, wouldn't an order reassigning parenthood to her birth mother go some way towards meeting that objective?
Would go to meeting the objective in relation to giving her the legal status of being, bad word, but a word repatriated to her birth family. The difficulty that she has had in this case overall, which I think I've explained in our written case, is this almost netherworld that she occupies between, on the one hand, rejecting a status that she has as an adopted child and completely disassociating herself not only from that status but also that family, whilst on the other hand, in terms of her lived reality, the factual outcome of her situation is that she sees herself to be part of her birth family but has absolutely no legal connection with the members of her birth family, and it would be the same for her child.
But wouldn't readoption by her birth mother solve that? Because it would bring to an end any legal relationship of parenthood with the adoptive mother and revive or at least transfer the parenthood relationship to her birth mother. She would be legally not in a netherworld, she'd be now in the new world.
but she would still acquire and retain the status of an adopted child.
Well, that's a different point. That's not about being in one camp or the other.
No, and
That seems to be suggesting there's some stigma associated with being adopted, and she doesn't want that stigma.
yes,
but-
that's probably the word I
But,
was.
but if it's adoption by her birth mother, is that realistic?
Well, it would mean that she would belong to her birth family, but as a consequence of being adopted into that. I think for her, the position is the stigma which would attach in relation to that.
Have exactly the same legal relations with all her relatives that relatives had with their relatives.
Yes, I mean, in terms of her legal status in relation to the people with whom she identifies as being a family member, so her biological half-siblings and others, that status legally does not flow.
One can't help feeling that position.
I think one of the difficulties in this case, which was alighted upon, I think, in the appellant's case, was the inadequacy of the support which was provided in relation to the particular, and also the explanation that was offered in relation to life story work and others. But I would submit it's the point of stigma that caused her to turn away from the notion of being adopted by her mother.
I just struggled to see, because for a period of her life she was adopted, and no matter what you do or say, that's the position.
And in terms of her identity, she resiles from that. I mean, in terms of the point I think was made earlier by my lady about name change and whether both of the children had changed their name. One of the options which Mrs. Justice even did allow for her was to change her name to BM's surname, which she has attempted to do but has been confronted with some difficulties in relation to achieving that. But certainly in relation to how she presents herself, introduces herself, and also her own child, that is very much in keeping with the court's direction. However, her point was always that that would be no substitute in relation to having acquired a legal status in relation to claim that as a member of her birth. Those were the submissions I was going to make, simply to root a position in the circumstances in which she found herself. I don't know if there's anything else upon which I can assist at this stage, but I can certainly contribute to those other documents which have already been mentioned.
Thank you, Mr. Bow.
Thank you, my Lord.
Ms. Markham.
Well, my lords and my lady, I find myself literally, and in terms of submissions between the appellants, the respondents and the Secretary of State, which you probably picked up from the way in which the written case was presented on behalf of X. X does not, at any stage, ask that her status changes, and she's clear about that. And in particular, that's because she understands, and we've talked a lot about the difference between a legal identity and your natural or birth identity. And she understands that Section 67 of the Adoption of Children Act makes plain that this is a transformative order that transforms the legal status of a young person from that of being the legal child of one person to that of another person or persons. But at no stage does it alter the biological, genetic or natural parentage. And that perhaps is an important matter to hold on to when one's considering identity, and some of the other submissions being made, in particular some of the submissions made about what if there's another adoption. And we know as well that declarations of parentage can be made by an adoptive person to establish the parentage, the genetic parentage, without disrupting the adoptive order. And you will see from the position of X that it's at paragraph 10 of my written note on her behalf, along with Ms. Khan, who sits behind me, who I should have introduced in my nerves. I forgot, my apologies. At 164, X supports certainty in the statutory scheme and in the making of adoption orders. If and it's very much if the court determined that there is a route to revoke a validly made order. She is clear through those representing her, so through myself and Ms Khan, that that should only arise in exceptional circumstances and with very careful scrutiny. And that's because she is very clear, and in the review of the case law, in particular NNS of last year, that the adoption principles, the Adoption and Children Act, has been given careful scrutiny by not only the courts in this jurisdiction in terms of proportionality and ensuring that any of the orders made are proportionate with consideration to the welfare checklist and the best interests of children, but also it's been considered both through the work that went through to the creation of it, it being a major piece of legislation, with much parliamentary debate over the course of a decade. And of course, looked at with care in some of the European cases. And I've taken, my lord and my lady, to paragraph 167 in NS, which is at 2171, which is the review by the European Court that the court has recognised that it has a duty to facilitate reunification and rebuild the family, but that's not open-ended, and that when a considerable period of time has passed since the child was originally taken into care, the interest of a child not to have his or her de facto family situation changed again may override the interest to have family reunited. But that the adoption permanency plan arises when there are no real prospects for rehabilitation or family reunifications, and they are created when it's in the child's best interest that he or she be placed permanently in the new family. And they looked, of course, at the balance of the Article 8 rights, finding in that case that the making, and in that case it was the focus on the non-consensual aspect of adoption, is an interference with the Article 8 rights of the natural parents, the birth parents, and arguably of the children, but it was a proportionate interference and a necessary interference when standing back and having consideration to the wider interests, in particular within the interest and understanding of the framing of child protection legislation in the jurisdictions of England and Wales. So, my lord, my lady, if this court, having consideration to those principles and the approach just last year, finds the view that in relation to revocation, that in considering non-consensual adoption as the courts did in NNS last year, that the aspect of revocation is considered within that, and they looked at the entire framework of the Adoption and Children Act.
Where's revocation considered in
it's
NS?
Not.
Oh.
And that's the point. So, and that's why I use the word if. It's not. Okay. Because it was framed on non-consensual adoption.
Yeah.
So the point of revocation of itself hasn't yet been subject to the scrutiny of the European courts. But for the purpose of this appeal, if my lords and my lady consider it has been considered as part of the consideration of the Act, then on behalf of X we say it has been considered and it is Article 8 compliant. And certainly, I know that my learned friend, Mr. Goodwin, King's Counsel, addressed you on whether or not he is seeking to argue that if my lords and my lady say it's compatible, then that is the end of it. What the courts didn't do in NS is look specifically at revocation, nor did they consider any of the other Articles 2 or 3. My lady, that doesn't arise in the context of this case anyway. We are talking about the Article 8 rights, the disruption of family relationships, the creation and transformative creation of new relationships, and whether or not Section 55 of itself and or standing within the entirety of that legislation is incompatible.
I mean, in NS, I'm looking at paragraph 167 on page
Yes.
2171.
Yes.
In the last part of that paragraph, the court does seem to have understood that it was looking at someone being placed permanently in a new family.
Yes,
That seems to exclude, on just the way they express it, seems to exclude revocation, because otherwise it wouldn't be permanent.
and the part that I've pulled out into our written case and highlighted emphasises that it is the permanent nature of the adoption that was considered in that case, and saying that there are times when, and you can see as well at the last sentence, my lord, at 168, it follows from these considerations that family ties may only be severed in very exceptional circumstances, and because they're looking at the lifelong permanent severing of those ties. So whilst the word revocation isn't considered, the court is looking at the transformative effect of the adoption order, what that means in a permanent, lifelong way. And of course, the welfare checklist that the courts in this jurisdiction employ look at whether or not it is necessary and proportionate with regard to the welfare of the child across the entirety of their lives to make the order, because the order is to be made lifelong. On behalf of X, we considered, we set that out as her understanding of the lifelong nature of the adoption order. She understands that that was what Parliament intended, and sat within the framework of other cases that follow in the jurisdiction about the necessity to look with care at the lifelong need for an adoption order, to give a sense of a lifelong family and to allow a child to have family bases outside of the care system. Looking then in the rest of the argument, we asked our questions, if we're wrong about that, is there other ways that this transformative order can be set aside? If there is no framework for it in the statutory legislation, and looking at Section 55 within the framework, there is no other interpretation other than that it's a lifelong order, then we ask ourselves, can you step back and find another way of undoing that transformative order? Because to undo the order is what the young person would be asking the court to do. And we say that in statutory framing, there is no way.
What about readoption?
Without the readoption.
Sorry,
you
can readopt.
You could readopt.
Right, well, that would be a way.
That would be the way, yes.
Okay.
So then we turn to inherent jurisdiction. And of course, on behalf of X, we picked up on paragraphs 63, 69 of the Court of Appeal decision and the position that the Secretary of State took in that appeal, that there might be, in very small, exceptional cohort of cases, a residual framework to protect a child or children and to revoke the adoption order. Having sat and listened and considered to all of the arguments, I think the principles I would agree and acknowledge on behalf of X is that inherent jurisdiction, so far as it falls in the parent's patriarch jurisdiction, comes to an end when a child attains the age of 18. There may be arguments around best interest and other decisions for an adult who lacks capacity, but I'm not going to go there at this point in time. There are no cases that we can look to or assist the court in relation to provide a firm foundation of inherent jurisdiction being used to define and or support changes of parentage. They are considered in a cohort of statutory schemes, including the Children Act, Family Law Act 1986, Declaration of Parentage, Adoption and Children Act, the HFEA, all of which are statutory schemes that set out how one acquires legal parentage. Common law, of course, provided for a married man to be given legal status as a parent of her father when he may not be. But that has been managed by provision within the Children Act, and there's a Court of Appeal decision, I think, on its way that confirms Section 4 of the Children Act being linked to genetic parenthood to be defined as a father. But save for that, I think it is right to acknowledge that there are no other ways that I could assist this court with to identify parentage arising from anything other than those statute-based black letter law. It's very different for a person, a young person, and X on whom I appear on behalf of, and I must not lose sight of that, is 19. She has experienced and has gone through all the permutations of being a child who's gone through the birth system, the care system, and been adopted. It is her view that there must be certainty, but equally there should be a way, in really exceptional circumstances, where an adoption order may be revoked. But she understands that the certainty arises from the Adoption and Children Act. And she understands the principles of that certainty as being a young person who has been experiencing that certainty to have a new lifelong family, and she retains a relationship with all of those whom are reported to her, including her adoptive mother. I probably have sped through my 15 minutes, but I wanted to pick up on only those points that I thought were right and appropriate to address my Lord and my Lady.
You've dealt in your written case with the Human Rights Act and
Yes.
Compatibility, but are you aligning yourself with Mr. Goodwin and saying it doesn't arise, or what's your position?
I set it out because it seemed right that it would be the only avenue to persuade this court that you would interpret Section 55 as requiring a read down to be incompatible with Article 8 and or Articles 2 and 3.
So is that your case?
No, it's not.
Okay.
Because I've taken to NNS, and if NNS, we say, has dealt with the compatibility point,
I see.
I set it out there as the forum for arguing it.
It's quite difficult to read down Section 55 because it's a very specific provision.
It is. It leaves a lacuna as to whether or not there are any other ways to revoke, because it's very specific. It's more about reading down the entirety of the legislation as to whether or not there is a lacuna in other ways in which an adoption order might be revoked. But then one reads the explanatory notes, one reads and goes back to the white paper, and one looks at NNS, and it is clear that the parliamentary intention behind the Adoption and Children Act was for it to be a lifelong order. Yeah. So that's how I approached that. But I set out Section 3 in the read down to ensure that we had considered all possible avenues of different ways to consider whether there was a small gap or a correct interpretation that was other than that in NNS.
And my understanding is that your first proposition was the inherent jurisdiction comes to an end when 18, but your second one was that there are no cases on inherent jurisdiction to support changes of parentage. So really the first proposition matters not, because there is no inherent jurisdiction.
No, well, my Lord, it would only be if there was an exceptional situation that arose that Parliament could not have contemplated, or was outside the ambit of contemplation, to protect a young person, and when one considers their rights, including Section 2 and 3 and Article 8 rights. But that would probably be an application that's made on the basis of those facts, and those principles at that time.
I have great difficulty in understanding how they could possibly arise.
Well, really. It would be, my Lord, the situation, for example, perhaps of a trafficked child who is then adopted, stolen child who wants to reclaim their birthrights in a way and says an adoption order would never have been made, and it was because of their subjecting to degrading and inhumane treatment that they'd found themselves in that situation. I mean, I'm looking at a wide scope, but I think it would have to be that type of situation.
Yes, I mean, just say, for example, you had the case of a stolen or trafficked child.
Yes.
And an adoption order were made of which the natural parents were completely unaware.
Yes.
Then that's the kind of situation where I think the President was envisaging the possibility of an appeal out of time being allowed.
And arguably. And if an appeal out of time wasn't made, then there ought to be a remit for the courts to consider, was that child subject to such degrading and inhumane treatment that their convention rights need to be or required to be considered alongside Article 8 rights because of the adoption order made. But I think that is the type of exceptional grave circumstance I understood the Court of Appeal were considering. And on the facts of this case, we say it's not. Just going to turn my back if I may. Ladies, may I assist any further?
Thank you very much indeed, Ms. Markham. And Ms. McLinn.
Yes, my lords, my lady, I appear on behalf of the Secretary of State for Education alongside Mr Wilson, the Secretary of State holding responsibility for policy in the area of adoption. We invite this court to uphold the decision of the Court of Appeal. We say that the Court of Appeal was right to find the jurisdiction to revoke adoption orders is and should be limited to cases on appeal. We've looked...
No, if I can just interrupt you. I'm sorry to interrupt you so early, but we were taken to some paragraphs in the judgment this morning that suggest more wiggle room, if you like.
Yes.
And there's a question as to whether, in fact, there's any jurisdictional basis for the wiggle room. So at some point, it would be helpful to know your position in relation to those.
Well, I can deal with those very briefly now. It may be that I touch on them again during the course of my submission. There are two caveats that are made in the judgment. The first comes at page 66, at paragraph 63, where the Court of Appeal say there may nevertheless be very narrow and specific instances in which the High Court finds it necessary to take adoption. But they will arise only where for some reason an appeal in or out of time isn't possible. I have to confess, neither I nor Mr Wilson have been able to understand exactly what the Court of Appeal were referring to there. That appears on the face of it to contradict the conclusion in the rest of judgment. We don't see that G&G, which of course was about a surrogacy situation and parental orders, assists in relation to that, because of course the policy issues in relation to surrogacy are completely different than those which pertain to adoption. And so, in relation to that point, we don't know what the Court of Appeal was saying, and we say
you're not endorsing that part.
We're not endorsing that part.
And the other passage was paragraph 69.
And the other paragraph is paragraph 69. Now, what the Court of Appeal there appear to be considering is an appellate power rather than a first instance, which makes it slightly different to paragraph 63. But nonetheless, we also find it difficult to understand how the convention could require an adoption order to be revoked, bearing in mind the other protective arrangements that are available within statute to protect children. Perhaps, as my Lord Stevens says, the Court of Appeal simply didn't want to close the door completely, bearing in mind that we are considering potentially vulnerable children. But we find it difficult to consider what particular circumstances that the Court of Appeal are thinking about in that. And we agree with them that in particular, it's highly unlikely that Article 8 would ever require the court to act such a way if an appeal wasn't possible. So, my lords and my lady, that's what we say in relation to those two paragraphs. Those are some areas where we depart slightly from the overall conclusions that the Court of Appeal reached. But we don't say that they undermine the conclusions that they reach, which, as I say, we support, because we say that an analysis of the case law supports the overall conclusion that they've reached. And secondly, having considered the primary materials and the predecessor legislation in a way that the Court of Appeal didn't, because nobody brought it to their attention, we say that they very firmly support the overall conclusion that the Court of Appeal reached in the court below. So, by way of opening, we will address in our submissions 4 key areas. First, we say a validly and properly made adoption order is permanent and irrevocable. We say that's clear from 4.
Isn't the first question whether there is any inherent jurisdiction at all to change the status of parenthood?
Yes.
And because it's only if such a jurisdiction ever existed that
yes.
you then look to see whether or not it runs counter to the legislation. And so what do you say about whether there was ever an inherent jurisdiction to change parenthood or to extinguish a parental relationship?
We say that such a jurisdiction didn't exist, and if we haven't made that clearly enough in our written submissions, then I apologise, but we do say that adoption is a creature of statute. We refer to the fact that there was an informal situation prior to 1926 where children were informally adopted. But there was never any legal footing for that. There was never any common law recognition of that situation, which is why the statutory provisions in 96. But even if there were, we say it wouldn't be appropriate to invoke the inherent jurisdiction in the circumstances, reasons that we set out in our written case.
You don't get on to the second question if the first question, if there is no inherent jurisdiction.
Yes.
We don't need to get on to the second question.
No, I mean, we will address those points because they've been made by other parties. The other aspect that we probably don't need to come on to is the Article 8 aspect of this, because we don't understand any party to be arguing that Article 8 creates a requirement or an obligation on the state to provide a mechanism for revoking a validly and properly made adoption order. Although we did address that issue within our written case, as the court will see towards the end of our written submissions. So, my lords, perhaps at this stage it would be helpful to look then at the first area of our case, which is in relation to the background materials and the wording of the Adoption Children Act itself. But forgive me, before we do that, I would like to draw the court's attention to the relevant policy principles which we say are in play. And we address those in our written case at page 212 of the bundle.
I'm just thinking aloud, so please forgive me, and looking for guidance from those with a lot more experience of this area of family law than I have. When one thinks about the parens patriae inherent jurisdiction, we've seen the definition of it in terms of protecting people who cannot protect themselves. And examples of it one thinks of are protecting the health of a child, for example, by authorizing medical treatment, protecting confidential information, the rights of confidence that a child has, protecting a child's property, these are all to do with a protective jurisdiction to preserve different kinds of interest of the child. I'm wondering if there's any... ending a parenthood relationship is a quite different type of exercise.
Yes.
And I'm wondering if there's any example of the use of inherent jurisdiction that would be analogous to that.
No, my lord, it's also, of course, used in the concept in the area of child abduction, which, of course, has been addressed by some of the interveners within this appeal. But again, that's very much in a protective situation, usually fairly short-term measures, in fact, to enable welfare decisions to be made about children. But it's a completely different area, we agree, than the area suggested by here.
I mean, I think it did extend to deciding who a child would live with.
Yeah.
I've got at the back of my mind,
Yes.
there was the Bernardo's case, which addressed that. But that's not in terms of parenthood, that's in terms of where the child will best be cared for.
No, well, of course, that was the whole point of wardship before the Children Act, in terms of both local authority powers and the powers of private individuals in terms of where a child should be.
Yes. Yes, so there's no analogous issue of what's effectively status. Thank you.
I just turn my back very briefly.
I suppose you could make orders that an abusive parent shouldn't come into contact with before we had the modern statutory instruments.
Yes. Yes, you could grant an injunction to protect the child's person or...
Yes.
Yes, but of course that's about, and there are, of course, within the Children Act, a specific issue order under Section 8 can narrow the exercise of parental responsibility, it can restrict the exercise of parental responsibility, but that's about the exercise of parental powers. It's not about the status of parenthood itself. So that's a different area. So, my lord, my lords and my lady, I accept that to a certain extent, if the court does reach that conclusion, then some of our submissions are, in a sense, academic. But we would seek to address the statutory scheme in any event, because we do say that it's important to set that out, but also to look at the policy issues engaged within this appeal, which we set out at paragraph 50 of our written at page 212 of the bundle. We say that legislation has been drafted in clear and unequivocal terms, so that adoption creates complete and a lifelong and irreversible transfer of parental status, allowing the possibility to challenge an adoption order in the way argued for in this appeal could undermine the commitment of adopters to their children and create a perception that adoption is reversible or a less serious undertaking. It could have an impact on the commitment of adopters to their children, which has been shown as being a key to its success. Could undermining the finality of adoption could negatively impact on the recruitment of adopters. And we also note that modern adoption can often include, as it did in this case, contact with birth families, either organised or, in some cases, contact that happens in an unorganised way. But for adopters to be able to have confidence in supporting that, we would submit that it's absolutely vital that they have confidence in the permanence of the adoption orders that have been made. And in that respect, in our written case, we draw the court's attention to the observations of Lord Justice Baker in the case of RER, which appears at 2118 of the bundle, where he sets out the changing nature of adoption, starting at paragraph 3 on that page. But what he emphasises is that even with older children adopted in the circumstances which they tend to be today, they need the security and permanency which adoption provides. But in many cases, they also need to sustain their relationships with some members of their birth families. All adopted children need to develop an understanding of their background and identity. For infants, that can be achieved through life story work and letterbox contact, but for older children, sustaining their identity in many cases can be best achieved by continuing direct contact with members of their birth family. It's to accommodate these twin needs that the concept of open adoption has come to the fore in recent years. So that need for permanency and security, which was identified by Parliament in 1926, very much remains, even if the cohort of children that are adopted these days and the way that they have relationships with their birth family has changed. So turning to the background materials and the wording of the Adoption and Children Act itself, we say that the historical material, old as it is fundamental to understanding how the Adoption and Children Act operates now and is good evidence as to the mischief that the statutory framework was aimed at when the original legislation was passed. And we emphasise that adoption was entirely a creature of statute. There was no underlying common law provision for the recognition of adoption at all. We say that the white papers leading up to the first legislation for adoption in 1926 and the white paper in advance of the refresh 30 years after that are important because they address head-on the issue of revocation on a welfare basis and demonstrate that Parliament decided not to go down that route in enacting the statutory scheme that it did. Thirdly, we say that there is a key thread in terms of the transformative and permanent effect of adoption and the status which it creates, which runs continuously from the 1926 Act through to the 2002 Act, which we say really involved Parliament adding more branches to the legislative tree rather than, as it were, cutting it down and planting a new one. Fourthly, we say that the fact that the Court of Appeal in the Webster case in 2010, which was clearly about the 2002 Act, drew from authorities which dealt with predecessor legislation, supports the submission as to that continuing theme of adoption running right the way through all of the legislation. So we suggest that it's helpful to look at the Hopkinson report from 1920, which is at page 2284 of the bundle. And in particular, at page 2292, which addresses the issue of revocation. Of course, in 1920, this white paper proposed that there should be a framework for revocation of adoption orders, and legislation was drafted that wasn't passed by Parliament. So in some senses, it's perhaps strange for me to be referring to this, but I'm doing that because it was then referred to in the subsequent white paper, demonstrating that they had considered this issue and chosen to take a different course. So if we look at paragraph 57 at the bottom of that page, the Tomlinson Committee suggested that adoption, once sanctioned, should be regarded as permanent and revocable only by order of the court. That the grounds on which an order annulling adoption may be made should be specified by statute. So just pausing there, when they were proposing that there should be a regime, they were suggesting that it should be set out in statute. And of course, we will say that the statute does deal with a very, very narrow basis for revocation, but not this basis. They say the welfare of the child should be paramount in deciding whether revocation should be allowed. There will no doubt be some cases in which, owing to change in the character, habits or ability of the parties or other circumstances, it would be desirable to annul the adoption, especially with the view to readoption of the child by another person or even its return to its natural parents. So we say that there was consideration at that time of the exact circumstances in some ways that this court is being asked to consider. A birth parent being able to care for a child and a child returning to their natural parents. And they then talk about procedural rules being put in place in relation to that. And at paragraph 58, the report also goes on to consider the possibility of an adoption order being annulled on the basis of serious misconduct for the child on the part of the adopting parent. So those those bases for revocation were considered and proposed, but they weren't passed by Parliament, and the legislation after 1920 failed.
Do we have a copy of that? There was a bill, wasn't there, that came out of the Tomlinson report?
There was. I'm afraid we don't, my lord. We can see if we can find that. I have to say some of these...
It'd be interesting to see what provisions they actually put into it, into the bill, which subsequently were dropped in the next.
What we do have is the 1926 Act, of course, but if we come on to now the Tomlin report, which is 1924, and that appears at 2217 of the bundle.
Sorry, do you say 2217?
2297. And then (2304) at paragraph 26, the issue of revocation is considered. Where the report says another matter of importance is the question of whether an adoption once sanctioned is capable of revocation. In our opinion, the notion of revocation is inconsistent with the notion of adoption. On the other hand, there's no reason why an adopted child should not, just as a natural child, be the subject of an adoption, that a child may be transferred from a first adopting parent to a second adopting parent. And then they go on to talk about the possibility, given that there shouldn't be a power of revocation, of having a probationary period. And I should have drawn the court's attention to page 2299 at the very beginning of this document, at paragraph 3, where the Tomlin Committee expressed their acknowledgement to the Hopkinson Committee. So it's clear that they'd considered the Hopkinson report, but reached a different view, which is that it's not appropriate for there to be a possibility of revocation for adoption orders.
And who made up the, who was on the panel of this, who prepared this report?
It's on page 2298.
It's 2298. So it was Mr. Justice Tomlin, and then a number of other ministers.
Yes, I'm not sure they're ministers, but are they?
Give me a moment. They're perhaps representatives, forgive me.
Presumably civil servants.
Yeah. My lords, then we come on to the 1926 Act itself, which the court finds at 2311. And the Act is short in comparison to certainly the more recent adoption legislation. And at 2313, in section 3, subsection A, the court will see that it's drafted in these terms, that before making an adoption order, the court shall be satisfied that every person whose consent is necessary under this Act and whose consent is not dispensed with has consented to and understands the nature and effect of the adoption order for which the application is made, and in particular, in the case of any parent, understands that the effect of an adoption order will be permanently to deprive him or her of their parental rights. So we say that that makes it clear that the intention was that the transfer of status would be permanent. And then at section 5 on the same page, upon an adoption order being made, all rights, duties, obligations and liabilities of a parent are extinguished, and all rights, duties and obligations shall vest in and be exercisable by and enforceable against the adopter, as though the adopted child was a child born to the adopter in lawful wedlock. And that framing carries all the way through to the 2002 Act, as we'll see in due course. And the court will see that there isn't any provision for revocation of adoption orders at all in this Act, save that at page 2315, the court will see that there was provision, as recommended by the Tomlin report, for a child to be adopted again. And in particular, we say the last 4 lines of that provision are relevant. Upon any application for such further adoption order, the adopter or adopters under the adoption order last previously made shall, if living, be deemed to be the parent or parents of the infant for all purposes of the
Sorry, which provision you reading?
This is section 7. So they are contemplating the possibility of another adoption order being made. That's the safety mechanism, as it were. But in those circumstances, the status, the parental status that would be extinguished is the first adopter. Again, we say that's very significant in terms of the intention for that permanent transfer of parental status being conferred. And a very definite decision to move away from, or to reject, perhaps a better way of putting it, the concept of revocation as set out in the Hopkinson report. There was then a substantial review of adoption in 1954 by the Hearst Committee, which led to the Adoption Act 1958. And again, we've referred to the report prepared by the Hearst Committee in advance of that legislation. That's at 2332, the bundle. And the particular consideration of revocation is at 2337. At paragraph 139, where the Hearst Committee referred to having received evidence about the possibility of revocation of adoption orders, and say we are convinced that an adoption order shall be final in all circumstances, except when it's quashed in appeal, when it's superseded by a further adoption order, and when a court has exercised the power which we recommend at paragraph 427 to annul an adoption order after a child who has been adopted by his father or mother has been legitimated. So it was in this provision that there was some very limited scope for revocation introduced to the legislation, but in very narrow circumstances. And in circumstances where, in terms, the recommendation within this report was that there shouldn't be a wider power to revoke. Because if the court goes on to read the rest of this paragraph, there was consideration of the potential to give a power to revoke where children had been adopted and then developed mental or physical difficulties. The adopters wanted to have the adoption order revoked, but the result of doing so would surely be to undermine the position of adopted children by exposing them to hazards which do not exist for children living with their own children. And that's consistent, we say, with the intention of treating adopted children just in the same way as non-adopted children, children naturally born to biological parents. And they go on to consider at the end of this paragraph the potential for an adopted person to make an application to revoke an adoption order. But they make the point at the end of the page that that wouldn't be any more desirable, for it also would tend to prevent the full assimilation of the adopted child into the family. So again, very much picking on the policy points that this court has referred to a number of times in the course of submissions already. And then those recommendations, we say, were fed through into the 1958 Act, which this court finds at 2340 of the bundle. That's section 13, which repeats the previous provision about extinguishing the parental rights of birth parents and vesting them in the adopter. And then on page 2342, revocation in the circumstances of legitimation. Forgive me, that's 2343, section 26. We then come on.
Is there a subsequent adoption provision in the 58 Act?
There is. I'm not sure that we've actually included that within the provisions, but there certainly is in later acts.
Yep.
We then come on to the 1976 Act, which was the next substantial act. We don't have the white paper in advance of that, but we've set out the excerpts in relation to that at 2351 of the bundle. No, forgive me, it's 2350. And then over the page to 2351, section 12, again, the making of an adoption order extinguishes any parental rights, vests it in the person in whose order the adoption order, in whose favour the adoption order was made. And then at subsection 7 confirms that an adoption order may be made notwithstanding that the child is already an adopted child. So that's been carried on through to the 1976 Act. And we say, importantly, over the page at 2352, section 39, the status conferred by adoption, the adopted child to be treated in law as if he had been born as a child of the marriage, but also subsection 2 shall be treated in law as if he were not the child of any other person other than the adopters or the adopter. So that's a new addition to what had been set out previously, and we say that that only emphasises, in fact, the permanency of adoption and the transfer of status. My Lords, we then come on to the next refresh of the adoption legislation, which is the 2002 Act. We've set out in our...
Can I just ask, was there a white paper before the 1976 Act?
Lord, I think there might have been, but it's not available online, I'm afraid, and we didn't obtain that.
If it were possible, since we're going to be given some
to
additional things, if a further effort.
I think it required. I think it needed to be obtained from the National Archive, but we can make arrangements to do
that. I see from page 2350 that it was a Consolidation Act. So
yes.
It wasn't changing the law, then it may not have been preceded by a report.
I think there may have been, but I think it may have been some years before, and it wasn't easy to find. But we can attempt to do that. There was a white paper leading up to the 2002 Act, which we've included at 2432. Although I think it's right to say that there isn't any discussion about the possibility of revocation in this paper at all. And we say that the significance of that is that there clearly wasn't any even contemplation of the fact of introducing a wider scope for revocation other than that which had been provided for in the previous legislation. That if Parliament had been contemplating for a moment widening the scope of revocation beyond the legitimation circumstances, that there would have been detailed discussion about that, bearing in mind how significant that change to the adoption legislation would have been. We say that the focus is very much on permanence. One can see that from 2444 in the bundle. At paragraph 2.12, where it says currently the options available to provide permanence for the looked after children are limited. Only adoption provides legal permanence, but it requires absolute severance of legal ties with birth family. So we say that language is very much in keeping with...
Sorry, I missed the page reference, sorry.
2444 and paragraph 2.12.
Thank you.
The other area which we say is relevant within, and within our written case, we've referred to some other parts where that permanence is emphasised, as do the Association of Lawyers for Children within their written case. The other part that we say is significant within this white paper is the introduction for the first time of the concept of special guardianship, and there's reference to that at 2455, where At paragraph 5.8, the White Paper recognises that it may not be appropriate for some children who can't return to their birth parents to be adopted, particularly when they're being cared for by extended members of their family. But nonetheless, they need a lifelong relationship with their carers. And so, at paragraph 9, there's reference to the introduction of the concept of special guardianship, which is described as a new legislative option to provide permanence, but short of the legal separation involved in adoption. And in fact, that was then carried through into the 2002 Act, which we'll look at in a moment. But if I could just refer the court to section 46 of the new of the Adoption Act 2002, which is at 2271 of the bundle. An adoption order is made by the court on an application under section 50 or 51, giving parental responsibility for their child to the adopter. The making of an adoption order extinguishes the parental responsibility which any other person other than the adopter or adopters has for the adopted child. And that's bringing the legislation in line with the 1989 Children Act, which introduced the concept of parental responsibility. But it very much matches, we say, the previous provisions which we've just taken the court to in terms of the operation of an adoption order. Over the page at 2272, 46 subsection 5, again repeats the provision that an adoption order may be made even if the child to be adopted is already an adopted child. And then section 55, which is at 2277. Sets out the only provision within the legislation for revocation in the very narrow circumstances of legitimation.
I see in section 47, subsection 9, the age bar is actually 19, not 18 for making an adoption order. Seems.
Forgive me.
That's on page 2273.
Yes, that's right. And if the court then looks over the page in relation to applications for adoption at 49 subsection 4, this is at 2274, an application for an adoption order may only be made if the person to be adopted has not attained the age of 18. So that's allowing for applications to be made up until the age of 18, but to be disposed of to the age of 19. Yeah. And that was in the context of older children perhaps being cared for who needed their status confirmed for immigration reasons. There's reference to that within the White Paper. But nonetheless, the application has to be made before their 18th birthday. And then, my Lord, I was just referring the court to page 2278.
Sorry, just if I can understand. So is that provision to sort of allow a bit of slippage? You make your application before you're 18.
Yes, exactly.
And as long an order can still be made up till a year later.
Exactly, absolutely. But it obviously doesn't extend beyond that, and the application still has to be made whilst the person is still a child. And then section 67 sets out the status conferred by adoption. Again, the adopted person is to be treated in law as if born as the child of the adopters or adopted, adopters or adopter. And not to be treated as the child of any person other than the adopter. So we say that the statutory language, although it's changed a little bit, has by and large remained virtually exactly the same. And if anything, the permanence of adoption has been emphasised rather than weakened in any way throughout the legislation between 1926 right the way through to 2002. The 2002 Act also introduced the possibility of special guardianship and amended the Children Act to that effect. And I would like the court to look at that very briefly, if I may. That's at 2412. And 2415 sets out the effect of special guardianship orders. Section 14C(1)(b) states that subject to any other order in force with respect to the child under this Act, a special guardian is entitled to exercise parental responsibility to the exclusion of any other person with parental responsibility, apart from another special guardian. So very much restricting, but not extinguishing, the parental responsibility of birth parents in that situation. And we say that's in line with the intention of special guardianship, to create a lifelong permanent caring relationship, but nonetheless not extinguishing parental rights. And then over the page at 2416, the court can see that there were provisions made for the variation or discharge of special guardianships, notwithstanding the fact that they were intended to be permanent and lifelong. At 14D subsection 5, it provides that the court may not grant leave to a parent, step-parent or a child to set aside a special guardianship order unless there's been a significant change of circumstances since the making of the special guardianship order. And we say that's relevant because alongside the other provisions which we've addressed in our written case and which other parties have dealt with, unlike other provisions, there is no provision for adoption orders to be set aside or varied. There is a...
So was 14D brought into existence by the 2002
Yes, it was. And so we say that that's a very clear illustration of the fact that Parliament was very much considering the possibility of revocation of permanent orders for children being cared for outside their family circumstances. They chose to have that safety valve in relation to special guardianship, and the fact that they didn't expand Section 55 we say is relevant because it obviously indicates, we say, Parliament's intention that adoption should be permanent. When a placement order is made, a parent is able to apply to revoke that but has to demonstrate a change of circumstances. When a special guardianship order is made, a parent can apply to revoke it but has to change a significant change or demonstrate a significant change of circumstances. But when it comes to adoption, we say that has a special status. This is clear in the legislation. There is no prospect, even if there is a change of circumstances.
What's the placement provision for discharge if there's been a change of circumstances?
Forgive me?
What is the section for
Yes.
a discharge of the placement order if there's been a change of circumstances?
Is section 26. Forgive me if I can just refer to our written case, or I think we deal with it there.
Sorry.
It's section 24
24.
of the 2002 Act.
And that was just a change of circumstances?
A change of circumstances. And that application can only be made before the child has actually been placed for adoption. And then it becomes a significant change of circumstances for a special guardianship order. And we've set out in our written case, and I won't repeat it now, the various things that other courts have said from paragraph 43 onwards. This is page 209 of the bundle, about the unique and transformative effect of adoption. And in particular, we would draw the court's attention to the case of Re Fostering or Adoption 2014 and the judgment of Lady Justice Black, as she then was, where she highlighted the differences between adoption and long-term fostering, noting that adoption would feel differently from fostering. Adoptions do, of course, fail, but the commitment...
Sorry, which page are you now?
So this is, we refer to this at 210 of our written case. It's also within the bundle at 1009.
Thank you.
Which case is it?
It's the case of Re.
The citation we've got is from...
There are a number of repeats, aren't there?
Yes, page 1009.
That's the internal page.
Oh, forgive me.
Is it page 2044?
It's 2022. Yes.
Oh, 22.
I'm sorry, can you just say that page reference again?
So
It was 2044, but I might be wrong.
yeah, so the actual page is 2044. I'm grateful, thank you very much. It's at paragraph 96. So there's acknowledgement.
It's Ray V rather than Ray B, is that right?
Yes. Okay. So there's acknowledgement of the fact that adoptions do fail. But whereas in a fostering situation, parents may apply for the discharge of a care order with a view to getting the child back to live with them, once an adoption order is made, it is made for all time. Unless, of course, there's another adoption order made. And we say it's relevant to consider what the Court of Appeal said at paragraph 44 of the judgment below. That means that just like birth children, as this court has already said, birth children and their parents have no way of extinguishing that bond, however much they would like to. And similarly, that's the position in relation to adopters. And we say that it's because of that transformative and permanent change of status that there are very stringent safeguards in relation to adoption. And we set those out at paragraph 49 of our written case at 211 of the bundle. And we won't take the court through each of those. But we say that there are a number of safeguards there, including the requirement to look at the effect on the child throughout their life at the time the adoption order is being made, and very strict requirements in terms of information that's required, medical reports, for example, being required in relation to the child and adoptive parents, which very much reflect, we would submit, the permanent transformative nature of adoption. And added to that, we say that, of course, there are safeguards if adoption orders fail. Adopted children, just like non-adopted children, can be taken into care. Adopted children, just like non-adopted children, can be cared for people other than their legal parents. And there are a host of orders available to provide a legal framework in that situation, such as a child arrangements order, just as was made in the circumstances of this case. And of course, they could be adopted again, which is I suppose, the ultimate protection. My Lords, my Lady, we were going to deal with an analysis of the previously decided cases, but bearing in mind the way that that's been dealt with by the appellant, and bearing in mind the concessions that have been made effectively, that there's an acknowledgement that the appellate authorities don't establish an inherent jurisdiction and that the other cases appear to have misinterpreted those, I don't know if it would assist this court for us to go through those cases in any detail. We've set out our argument in relation to that in our written case.
No, I don't think I think we have enough assistance from your written case.
Yes. Well, if I could possibly just move on then to the issue of the inherent jurisdiction, I appreciate there's the fundamental point which the court has made about that. But even if there were a power under the inherent jurisdiction, would it be appropriate to use that in the circumstances of the statutory scheme which we've just gone through in such detail? We would say fundamentally no, because...
Sorry, just to be clear, you are saying there is no inherent jurisdiction, and now you're coming on to why, even if there were, it would cut across the statutory scheme, or are you dealing with...
We certainly accept that there is no residual inherent jurisdiction because adoption was entirely created by statute.
Yeah.
Which is different to other circumstances where there was a residual power under the inherent jurisdiction to, for example, make orders in relation to where a child lives or a child being placed in the care of the state.
And again, just so I'm clear, I also understood you to be saying that, well, even if there had been an inherent jurisdiction, the terms of the statute are so clear that it would have been excluded by those terms.
Yes, absolutely.
So we've now moved on. We're now moving on from that, are we?
Well, I was just going to address that point in a little bit more detail. Looking at RET, if it would assist the court, simply saying that, bearing in mind the statutory scheme, even if there were a power under the inherent jurisdiction, that it wouldn't be appropriate to exercise it in these circumstances because it would go against the grain of the statutory scheme in place.
It just seems a slightly strange way of putting it, not appropriate to exercise it. Aren't you saying it's been excluded? It's not appropriate to exercise it because it's been excluded by the terms of the statute?
Yes.
Right, okay, that I understand, thank you.
We also say that it would be problematic because it would create uncertainty, because what's being suggested in this case is that a test of exceptionality would be the appropriate test to apply, which we say wouldn't leave any basis for predictability in terms of when it would be exercised. And we say that it would inevitably have an impact on the recruitment of adopters who may fear that an adoption order could be set aside for some unforeseen change of circumstances at some point in the future. And we also question what is said by the appellant as to whether in fact the circumstances of this case really are particularly exceptional. We make the point in our written case that actually the circumstances in this case are very similar to those in the AX case, where an adoption broke down and a child returned to the care of her birth parent. And in the written case of Coram Bath, who intervene in this appeal, at page 266 of the bundle, they also make the point that in their experience it's not unusual for children to return to their birth families or to reconnect with their birth families in situations where an adoptive placement breaks down.
Sorry, which paragraph? So yes, 9.
Yes. And we say that even if the court were looking at the possible exercise of the inherent jurisdiction in the case of RET at 2236, the court has already looked at this part of Lady Black's judgment when she was considering the possibility of the use of the inherent jurisdiction within the context of secure accommodation. At F, he says, I would endorse that of being of particular importance where the inherent power exists for the protection of children. Relevant in approaching the issue are both the words used in the section and the section's origin. So again, she's making it absolutely clear there that it's very important in considering whether the inherent jurisdiction may be used as a safety net to look at the statutory framework and the origins of the statute in the way that we've just done. So we would submit that very clearly, having looked at that statutory framework, that there wouldn't be any scope for the inherent jurisdiction being used in a protective way in these circumstances, because the statutory framework itself is absolutely clear that revocation isn't the appropriate course in that situation. If protection is needed, one looks at the protective arrangements for children that are available for non-adopted children, rather than considering the possibility of revocation of an adoption order.
Can I just ask one technical question? Where an adoption order is made, is there power in the court to make a second adoption order, effectively removing or changing the parenthood of the child, against the wishes of that first adoptive parent?
Yes, because welfare is paramount in that situation, yes, and that's really important. One of the points that's made on behalf of the appellants in this case is that there isn't any framework if there's no jurisdiction to revoke for considering the welfare of the children. We say, on the contrary, that's not right. If there is a fresh adoption application, the welfare of the child is paramount, and the welfare checklist applies. Exactly the same situation pertains if a child arrangements order application is made. So there is absolutely a framework for considering the welfare of the children. And that does mean that there could be an application by a number of different people in relation to a new adoption order potentially. Although, well, it would have to be by a new adoptive parent.
Right. So the reason I raised it is that somewhat undercuts the point you made about there being an impact on recruitment of adopters if they thought things could be changed, because things can be changed.
They can, but only if there's a further adoption application. And of course, all of the stringent safeguards that we've mentioned would apply.
Yes, thank you.
So I accept to a degree that there is that certain undermining in some ways of the permanence of the scheme by having that safety valve. But that was a choice that Parliament made when they enacted the legislation. Other jurisdictions, as you will have read in some of the authorities, do have the possibility of revocation for adoption orders, but Parliament in this country decided not to go down that route, but to provide that possibility of readoption again. My Lords, my Lady, at page 231 of our written case, at paragraph 101 onwards, we deal with the human rights aspect and the potential points that might be made in the event that it was being argued that the Act was incompatible with the Convention or that there should be a read-down, but bearing in mind that none of the parties to this appeal are making those points, even if there is no scope under the inherent jurisdiction to revoke an adoption order. I don't propose the court to take the court through all of those provisions and paragraphs unless it would be of assistance.
No, I don't think so. Thank you.
I could just turn my back briefly then. No, those are my submissions unless I can assist the court any further.
Well, thank you very much indeed, Ms McLean. Mr Goodwin.
Very briefly indeed. First of all, in response to the exchange between my Lord Sales and Ms McLean a moment ago about the way that welfare would be taken into account if there were a second adoption application, the extent to which that might affect the question of recruitment. Can I I hope to take the court to page 2269 of the bundle, in which the court will find section 1 of the 2002 Act, and therein you will see, under subsection 7, that the expression coming to a decision relating to the adoption of a child, which is the phraseology that one sees first in subsection 1, applies in relation to the court coming to a decision in any proceedings where the orders that might be made by the court include an adoption order, and then in brackets, or the revocation of such an order. Now, plainly within the terms of the statute, that latter language is a reference to section 55. I simply flag that up because it means that whether a child is facing revocation through section 55 or whether there is a re-adoption application, welfare will be the paramount consideration.
Yes, thank you.
In relation to the Secretary of State's other submissions, they have, of course, been heralded on paper, and as such, my earlier oral submissions were intended to address them. I would only say that, apart from acknowledging realistically the force of the submissions made in respect of the different committees and the successive pieces of legislation that preceded the 2002 Act, it is one thing to conclude that Parliament has considered for general purposes whether there should be scope for revocation and to have limited it within the statute to a legitimation context. But it is another thing to conclude that Parliament had specifically considered the unique circumstances of the present case where all parties consent to revocation and the adoptive status no longer has any meaning for one of the children, and we would say, and others would certainly say, may indeed be harmful. So the intention of Parliament within the 2002 Act, and indeed in terms of the white paper that precedes it, is to try to shore up stability and ensure permanency if possible. It's to try to ensure that adoptive decisions in respect of children are made with as little delay as possible so as to meet their welfare needs. It's to ensure that adoptive parents have access to support services in order that the intended permanency can be successful and the stability of the placement maximised. But none of the provisions on our case address what happens when all of those things come to nothing and the placement has broken down, the child returned to a birth parent, and more importantly, rejects entirely her adoptive status and has the support of her adoptive parents in seeking a reversal. Finally, from me, in terms of the argument about uncertainty and unpredictability, I reiterate the point I made earlier about the paucity of decisions at first instance, in which revocation has been allowed in the absence of any procedural problems at the time of making the original order. If the floodgates had been opened by the assumption of the existence of such a jurisdiction, we would have seen far more cases, and we would have seen uncertainty and unpredictability playing itself out on the ground. We have, in fact, seen the reverse. So in those circumstances, the existence of a jurisdiction has not undermined what is intended to be the primary purpose, but we say not the exclusive purpose of the Act. Those are my submissions in reply.
Thank you very much, Mr. Goodwin.
Thank you, my Lord.
Well, we're grateful to Council for all the assistance you've given us. We appreciate that we raised some issues which may not have been anticipated. I'm afraid we have to try to get to the right answer. We'll now take time to consider all we've heard and let you have our judgment when we can.
Thank you, my Lord.
Thank you.